We would like to extend a very special thank you to our friends over at Alley Moss, Rogers & Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Maritime arbitration has been around for hundreds of years. Now we have a new forum to solve our disputes. The IYBA has created the International Yacht Arbitration Council to solve our disagreements. We have experienced maritime attorneys and yacht brokers to serve on our panels, people who know the law, who know boats, and who know the yacht business. IYAC arbitration can handle yacht claims, contract, purchase, and commission disputes privately, quickly, and less costly than going to court. Sometimes disputes happen, and when they do, the IYAC is here to help you solve them.
IYBA would like to thank Yacht World for their support of this year's 25th Annual Yacht Sales the Law. IYBA would like to thank Howard S. Reeder, Inc. for their support of this year's 25th Annual Yacht Sales the Law.
Do you want to generate leads? Is free your favorite price? Then you need to check out IYBA.pro. IYBA.pro is your industry-owned platform for all listings and marketing. Create robust yacht sales and charter profiles, elegant marketing material, have access to all your exclusive data, and enjoy premium search engine optimization by signing up with us. For more information on how to join IYBA.pro, call the IYBA headquarters or email me at casey@iyba.org.
We would like to extend a very special thank you to our friends over at Alley Moss, Rogers & Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Maritime arbitration has been around for hundreds of years. Now we have a new forum to solve our disputes. The IYBA has created the International Yacht Arbitration Council to solve our disagreements. We have experienced maritime attorneys and yacht brokers to serve on our panels, people who know the law, who know boats, and who know the yacht business. IYAC arbitration can handle yacht claims, contract, purchase, and commission disputes privately, quickly, and less costly than going to court. Sometimes disputes happen, and when they do, the IYAC is here to help you solve them.
IYBA would like to thank Yacht World for their support of this year's 25th Annual Yacht Sales the Law. IYBA would like to thank Howard S. Reeder, Inc. for their support of this year's 25th Annual Yacht Sales the Law.
Do you want to generate leads? Is free your favorite price? Then you need to check out IYBA.pro. IYBA.pro is your industry-owned platform for all listings and marketing. Create robust yacht sales and charter profiles, elegant marketing material, have access to all your exclusive data, and enjoy premium search engine optimization by signing up with us. For more information on how to join IYBA.pro, call the IYBA headquarters or email me at casey@iyba.org.
We would like to extend a very special thank you to our friends over at Allie Moss, Rogers and Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Hello, and welcome to Yacht Sales the Law 2020. I'm Paul Flannery, Executive Director of the International Yacht Brokers Association. On behalf of our Board of Directors and our sponsors, Allie Moss Rogers Lindsay, Lauderdale Marine Center, Yacht World, and the folks at Howard S. Reeder Incorporated, we welcome you to the virtual presentation of Yacht Sales the Law. This year, we're going to enjoy a 7-episode series called As the Prop Turns, where we'll introduce Bubba Calhoun and Bill Boatwise, our two brokers. David Moss will moderate our expert panels as we analyze each segment. Stay tuned for Act 1 of As the Prop Turns.
Our internet connection today is brought to you by the team at JV Connectivity, Superyacht Cellular Data.
Yes, I'll put you through.
Bill Boatwise. Mr. Ficarino, Owensville, Missouri. Where exactly is that? just outside of St. Louis. Great town. Haven't been there in a few years. Mr. Ficarino, to what do I owe the pleasure of this call? You want to sell your boat. Tell me, what type of boat do you have? An 88-foot Limone 2004. A great Italian build. Tell me, why do you want to sell the boat? Okay, you want to upgrade the boat. That's what a lot of people like to do. Tell me, you sound American. How is the boat flagged? It's a Cayman Island flag. So it's a foreign-built boat. It's a Cayman Island, foreign registered. Tell me, have you paid duty on the boat? You've paid duty, you claim to pay duty, but you don't have a receipt. Okay, you think the previous owner did it. Tell you what, that's something that we'll have to contact a customs broker, and we'll get to the bottom of the duty payment. So, Mr. Ficarino, what is the name of the boat? Spicy Meatball. Wow, that's a great name for an Italian-built boat. Where exactly do you keep the boat? Titusville, Florida. Okay, now are you using the boat a lot? Is the boat sitting? Tell me what's going on with the boat at the moment. You've just done a maintenance period, you've spent a little money on it, and you're ready to get the boat sold. I understand. You like to keep it in Titusville because the dockage is cheap. Well, I can certainly tell you that Fort Lauderdale will be a bit more expensive in terms of dockage than Titusville. However, in Titusville, the boat is simply going to be on the market. We want the boat in the market. So I think it'd be a worthwhile cost to get the boat down to Fort Lauderdale. We're going to have a lot more opportunity to sell the boat. I think we'll be able to generate a lot more leads with the boat here in Fort Lauderdale versus Titusville. Just out of curiosity, Mr. Ficarino, how did you get my information? Okay, so a friend of yours at a cocktail party gave you my number. That's great. And you have a few friends that you want to put in an exclusion list in the listing agreement. That might be an issue because you mentioned that the boat is on a cruising permit. And it's also not, being that it's on a cruising permit, it's not going to be available for sale to U.S. residents while in U.S. waters. Okay, so if we're going to put the boat on the boat show bond, there's only 15 days a year that we're going to be able to sell it, Mr. Ficarino. Yeah, and the first thing we're going to have to do is talk to a customs broker and check on the duty paid. So, Mr. Ficarino, what do you think the 88 Limone is worth? So you think the boat is worth $3.8 million, and you've been looking at similar boats on Yacht World, and you've come to the conclusion that you think it's $3.8 million. So, Mr. Ficarino, I've done just a few quick searches here, and I can see that based off the size, the vintage of the boat, the build, I think that a retail asking price of somewhere around 3.25 might be a little bit more aggressive than the 3.8. So the commission structure as follows. We sign at 10%. Okay. So Mr. Ficarino, if you want to work at an 8% commission rate, we're going to reduce the marketability of the boat. Well, yeah, other brokers are not going to be interested in the boat at a reduced commission, and that is something that I had to lead with in a conversation with the brokers, that I have to disclose to them that I have a reduced commission. And at the end of the day, Mr. Ficarino, you will always be in control of the actual price of the boat. The buck stops with you. Any offer that I bring you is going to have a gross number and a net number. If you don't have your net number, we don't sell the boat. Perfectly in that. And Mr. Ficarino, the other thing, if we start at 8% commission, tell me real quick, what 20% of my job do you not want me to do? Yeah. Mr. Ficarino, our listing agreement is put together by some of the finest maritime attorneys in our industry, and you're more than welcome to have your legal team take a look at our listing agreement, but I think you'll find that it's up to snuff and up to par because we've had some of the best maritime attorneys format and put this listing agreement together. Yeah, so Mr. Ficarino, the next step is for me to put a listing agreement together with your boat's information, your information, and I'll get over that to you as soon as possible. Can you give me your contact information starting with an email, please? Charlie@spicymeatball.com. Okay, what I'm going to do is I'm going to send you our listing agreement and go ahead and respond to that with all the pertinent information you have on the boat as well as your contact information. Right, so once we get that central listing agreement back, the next step is for me to conduct a photo shoot, perhaps a drone shoot as well, on the boat as well. We'll get the boat photographed properly, and then... Okay, so you're in the middle of a couple of projects that you'll be wrapping up. As soon as you wrapped up those projects, we'll get the boat properly photographed and then get it into the marketplace. And also, Mr. Figueroa, what I'm going to do is I'm going to look in the dockage down here in Fort Lauderdale, somewhere it's convenient, somewhere where the boat will show well, and I'll get back to you with pricing and availability. Yeah. Mr. Figueroa, I'm excited. I think that this is a very sellable boat. I can't wait to get it into the market. I think you're going to be impressed with the marketing and the exposure that your boat is going to get. And I think we'll be able to get this thing sold in an efficient manner. Mr. Figueroa, again, thank you for the call. I'm excited that we're going to be working together, and I look forward to working with you in the future. All right, fantastic. You too. Bye-bye.
Welcome to Yacht Sales the Law. My name is David Moss. I am a lawyer at Alley Moss, Rogers & Lindsay in Palm Beach. I'm going to be moderating our discussions about the issues raised in As the Prop Turns. I am also a writer of As the Prop Turns. I am joined today by Bob Allen of Robert Allen Law, a maritime lawyer, and Trey Reeder of Howard S. Reeder, a customs broker. We're going to be talking about some of the issues raised by that first act. And then I'll be back later to discuss the other acts. Trey, I'd like to start with you because one of the things that Bill asked about at the beginning correctly was the duty status of the boat.
Right.
Is the boat duty paid? And I think the seller said that he believed the boat had been duty paid, but he didn't have any paperwork. And is that something that happens often? And what sort of remedies does an owner have in that situation?
Well, it definitely happens often. The main remedy is to try to find out when it was paid and then try to sort out what customs broker may have done that. There's not a database. We get a lot of questions about, hey, is there a database at customs? I can just tell them my boat name or my hull number and they can find it. My answer always is there isn't, because the same type of entry you make for a boat to pay duty is the same type of entry you get a container of socks from Indonesia. So there's hundreds of millions of entries. The onus is on the owner of the boat to have that. Us as brokers, we do have to keep it for 5 years, though, a record of an import that we make, and we can only search records of entries that we've made and imports on boats. So
if you can find out who the importer of record was, and it was within the last 5 years, generally you can get a copy of it.
Correct. Yes. If you know who that, if you can find out who the broker is, typically they can search for it. Some get rid of all their records after that's 5 years. We keep ours on boats only for as long as we possibly can, just because it does come up, and we get sometimes 20-year-old boats, and this issue comes up in a sale, and the buyer doesn't want to pay, or the seller doesn't want to pay the duty again. So we'll search it and usually can find it, but there's not really any other database other than what you just said, finding the original importer who did it. So.
And if for whatever reason you can't establish that duty was paid, what are the owner's options if he still wants to market the boat for sale?
Well, currently, I guess you can do a boat show bond, but it does limit you to only being able to show that boat to Americans for the 4 or 5 days of a boat show. It only lasts for 6 months, so you want to try to get it as many boat shows as you can in that 6-month time. And also, I guess the next thing would be a newer thing many have heard about, the FTZs, or foreign trade zones. And those are limited to geographical location of the boat, predominantly here in Fort Lauderdale. There's one up in West Palm Beach. I think they're working on some others in other parts of the country, but that really is the only other option. But that does allow you to be able to market the boat for brokers the entire time to Americans, that it's in a zone. But it does come with its own, the owner can't use the boat at all. So you do lose some of that, which with boat show bonds, you can still use the boat. And with the foreign trade zone, there's only 2 ways out of it. One is to import into the United States, or one is to export out of the free trade zone directly out of the U.S. So those are really the 2 main options, other than paying the duty again.
And if the owner doesn't want to pay duty but wants to continue using the boat, he could, I suppose, market the boat to non-U.S. residents if you have that restriction on all the advertising.
If it's listed as not for sale to U.S. residents in U.S. waters, then the boat is still usable in that way.
Now, I want to ask you about a duty issue, Bob. If a seller comes to you, or say a buyer comes to you and says, I'm interested in buying this boat, I've been talking to the seller, but the boat's not duty paid. Seller says, don't worry about it, we'll take the boat offshore, we'll close offshore. Is that something that would work, and would everyone be protected?
Well, I don't think so. But the first thing I'd do is I'd pick up the phone and I'd call Trey. And I'd say, Trey, what do we do to resolve this situation? But you don't want to put your owner in a position where they'd be violating the law. And because on paper, there's some pretty serious consequences to that. Most people don't get busted, so to speak.
Right.
But have you had experiences where people have been busted?
Not that I can recall where Customs has actually chased after someone for duty. We have had experiences where somebody, you've gotten close to signing an agreement, and then it becomes known that the boat's not duty paid.
And how about you, Trey? Have you had to deal with situations where somebody was busted for not paying the duty or showing the boat to a U.S.?
We have seen it. Mostly we've seen it in some of the sweeps that Customs does every now and then. It's very rare, but it's in Fort Lauderdale a lot, where they go to the shipyards and they'll end up talking to the captain. They'll see a for sale sign. They'll ask the captain, is the boat for sale? And they'll say, yeah, that's for sale. And they'll say, oh, well, how is it legally for sale? And we've seen a few of those. When fortunately, most of those were either U.S.-built boats that were non-exported, purchased here, or they were able to, a few days later, bring up the duty payment that they had and take it to Customs and get themselves kind of off the hook. There was an incident, maybe 5 years ago at the boat show itself, where there was a broker who had a listing, had a boat. It was Choi Lee, I believe, and they had not paid the duty on that boat. And Customs at the time seized it for its value. It was for sale for $1 million, and they basically put $1 million penalty on it. And then I'm not sure what happened litigation-wise with Customs trying to get that worked out, but that I have seen it happen before. But.
Well, the situation that I had that involved this was a boat that should not have been shown to Americans, and there was a contract on it, and there was no reason why the buyer should have been able to back out, because the boat had been accepted. However, at that point, the buyer went to get a lawyer, and the lawyer kindly pointed out the non-compliance with the law issue, and it gave them a tremendous amount of leverage in order to back out of the deal, and that's exactly what happened, and there was really nothing we could do about it.
Sure.
Yeah, I mean, that's the problem, is that really as soon as the boat's offered for sale, she becomes dutiable. So whether there's an agreement signed or not, if by the time you realize the boat's not duty paid, it's too late, the only way to cure it really is to pay duty.
Right, which that I would say is a fairly common call we get is, hey, we have a closing set up for this Friday. How quickly can we get the boat imported? Which, as you just said, the infraction has already occurred. It's the offering of the boat for sale prior to it being imported. When you put that product on the shelf here, it's got to be imported, just like anything else prior to. So
one issue that I actually don't think was raised in the segment, but I wanted to talk about, was an issue that we've seen recently with importing foreign-built boats, and the issue of EPA compliance. That recently has become an issue for CBP, and it has led to situations where people discover they are unable to import a boat because it doesn't comply with U.S. requirements.
Right.
How have you seen people try to work around that?
Well, there is no way to work around it other than what I stress to people is the first thing, especially brokers. Before you take a listing that someone wants to sell here, foreign boat, never been imported, the most important thing, at least from my standpoint, is finding out if those engines that are in the boat are importable. Because if the engines aren't importable, then the boat's not importable, which is a killer for a lot of deals. We've had deals that have gone all the way up surveys, the whole thing, and seen them fall apart. They'll do surveys overseas, they'll bring the boat here, and they say, okay, we're going to import it now, and we're going to get ready to close, and then they can't import the boat, which is a disaster for all aspects.
Well, Trey, is it solvable by keeping a foreign flag on the boat?
Yes, if you're not intending on importing the boat, then yeah, it can be a foreign flag boat and just cruise here, certainly.
So that limits the owner's use of the boat in the United States. It's kind of a pain in the neck.
Yeah, it adds another element, certainly, by being foreign flagged. So, but it is, yes, I would say a way around it would be that. And there are boats that do that. They may have intended to want to be a U.S. flag boat, ultimately couldn't, still decided, well, we'll just foreign flag and I'll just use it the way it is.
That works best for a Florida East Coast boat, right?
Right.
That runs to the Bahamas all the time.
Sure.
But if you're on the west coast of Florida, or anywhere up the coast where you want to come down to Florida, it does create
Sure.
a lot of paperwork hassles.
Yeah, and and with the foreign flag boats, you got to have the cruising licenses, and if you're 400 or 500 miles, not 50 miles away from a foreign port, to renew it every year and all that can certainly be a problem. So that's why, but I always say, EPA is the first thing, because if you can't get through that hurdle, then you can't import the boats. So
We've seen a couple of issues with the EPA certificates. One is just the awareness. People don't know about it yet.
Sure.
People are really just, I think, becoming aware of the issue with EIEPPs. And they'll say, well, we have EIEPPs.
Right.
So you're telling me I need something else. The answer is yes. It's a separate set of requirements for the EPA.
Sure.
And if the engines are not manufactured for the US market, even if they do, many of them do comply, but they don't have that decal or that placard on the engines.
Right.
And in a few cases, we've been able to go back to the manufacturers and get them to reissue it
Sure.
if it did in fact comply. But some manufacturers are totally unwilling to do that. So even in theory, you could have an engine that complies with the U.S. requirements. You just can't get it certified and you can't import it, which is very frustrating for owners.
Yeah, and we've had, like you said, a few helpful diesel builders that have ultimately said, oh yeah, well the engines are compliant, but the boat was built for a European buyer originally in Europe, so we just we didn't label them as such, but they're able to produce them if the serial number comes up with them as, oh yeah, this engine was built to spec. So
there's a cost associated with that, and sometimes that's a negotiation. We've had it come up quite a bit with foreign manufacturers of yachts that aren't really familiar with this. The typical salesperson will not be familiar with it, and even some of their the internal closers, the people in charge of processing the documents, aren't. So you actually face an educational hurdle, but we've been able to overcome it most of the time.
Sure.
I would say with EIEPPs in particular, that's probably our most common sort of thing that gets resolved post-closing. The boat needs EIEPPs, the seller wasn't aware, we have to tell the buyer that they're legally required, and oftentimes there's a holdback, or the seller provides evidence that they've paid to obtain the certificates, or the broker steps up and pays for the certificates, because those certificates can cost a few $1,000s, which is not a lot in the grand scheme of a yacht deal, but when it pops up on the eve of closing, people are not happy about it.
They aren't, and it's kind of funny because even though they are a few $1,000s, we're usually dealing in the context of boats that are worth millions, right? But still, as a matter of principle, people will say, I'm not paying for that, the manufacturer, the buyer, and it creates a little bit of tension and, fortunately, a little bit of extra legal fees.
Another thing that you mentioned that was in the video was the cruising license. He said the boat was under a cruising license. If he wants to offer the boat for sale, he will probably have to surrender the cruising license either way, correct? Yeah,
down here especially. Customs in the last few years has kind of changed a policy on that, or at least the way they interpret the way the law's written, that any offer to sell makes it basically null and void, and you should be surrendering that cruising license because it's no longer here for strictly private use.
Even though the boat's duty paid?
Yes, even though the boat's duty paid. I won't go into my thoughts on that or whether I agree or disagree with that, but it would be what they would want them to do, certainly.
Well, without getting into your thoughts, it seems kind of illogical because their job is to make sure that duties are paid on things that are imported in the United States. It really makes no sense at all to limit the movement of a boat when it's already paid its duties.
Sure.
So it just seems like one of these situations where over-regulation is an impediment upon business, right?
Right.
And so I'll say that so you don't have to.
Sure. Yeah.
I've always pointed out that, and Customs has not been persuaded by this, but I've always pointed out that the pleasure use restriction in the cruising license statute is the same as the pleasure use restriction for a recreational endorsement on a U.S. documented vessel. They can both be used only for pleasure. Nobody thinks that means that a U.S. documented vessel can't be offered for sale.
Exactly.
Right. Yeah, well, that's what I said. It changed. The regulation never changed. The language never changed. Just the policy changed. And just from my experience and dealing with captains, different ports as you go up north don't even consider it. One is navigation, one is a trade issue. Duty pay, paying duty, that's a trade issue. The other one is just the vessel movement. It's
Well, it's one of these things that gets institutionalized into a bureaucracy, and it's hard to change.
Sure.
It really is.
And yeah, and the reason I have my obvious feeling is not agreeing with it is also there's a ruling as late as 2011 that specifically states the exact opposite of what they're doing. I mean, it says in almost exact quotes that Customs has long held that entitlement to a cruising license is unaffected by a yacht being offered for sale, charter, or listed with a broker. So I've presented that before, kind of got pushed out the door with it, but yeah, down here currently, you would want to surrender it because if not,
Well, next time that happens, have the customer call his office or mine or one of the many other lawyer members of the IYBA, and let's make some money on that one. Let's file a suit. See what happens.
Now, do you think they would take the same view if it was offered with the restriction that it's not offered to U.S. residents?
It doesn't matter. I mean, we do cruising permits every day, and if it's listed for sale only in Europe and it says not for sale to U.S. residents in U.S. waters or only for charter in the Caribbean, they're taking the word any that says, any offer for sale and really stretching any, I think, into, any, anywhere. When realistically it only applies to here. So if the boat isn't doing any of those things here, I don't think that any of it really should apply.
So another issue that was raised in the segment that I want to talk to you about was the listing agreement. So to start, he discussed using the IYBA listing agreement, and I was hoping you could sort of talk about some of the ways that agreement protects brokers who are accepting boats to offer them for sale.
Well, the main way it protects brokers is that it lays out all the rules, right? If you didn't have a standardized agreement that was accepted in the industry, every negotiation would be infinite. It would be almost like a private jet purchase agreement where there isn't a standardized document and they haggle and they haggle and they haggle. So we have a whole set of rules that defines that. And the set of rules was developed by brokers with lawyers, looking at every possible situation that we could think of so that things would be easier. And in particular, the IYBA listing agreement has some protections to brokers that avoid litigation and give them certainty or a greater degree of certainty with respect to the payment of their commission. And one of those things is just putting in the agreement that the commission is 10%, right? So that it doesn't have to be negotiated all the time. It can be negotiated. We saw it negotiated here in the skit. But the broker made an excellent point. Which part of my 20% of my commission do you not want me to work? And truly, if you want to market a boat in the environment that we're in, a 10% commission makes sense. If it didn't make sense, the market wouldn't accept it. So that's one of the protections that we offer. Another protection is, and this is really important, particularly in the context of international deals, which we see with bigger boats, and we see many more international deals than we used to. And that is an assignment to the broker of the commission amount from whoever is holding the deposit. I was mentioning to David earlier that we had a situation where we were dealing with a European lawyer, we were dealing with a different purchase agreement, and the broker who held, not the broker, the law firm that held the commission was telling us that they were going to send the commission amount to the seller, and then the seller would have to pay the broker. Of course, that's what the MEBA agreement provides. But the EBA agreement provides, no, that money will come directly from the escrow holder to the broker. That's a huge, huge achievement that's been standardized into the industry as a result of this listing agreement. There are other advantages as well, but I would say that's probably the most important one.
So one of the things that's often an issue in listing agreements is after the agreement expires, if the vessel is sold to someone who was a client of the broker or who showed the vessel, the broker showed the vessel to that particular buyer. How does the EBA agreement protect brokers in that situation?
Well, the EBA agreement says essentially that if you showed the boat to someone while you had the listing, and when the agreement terminates, one of those people ends up buying the boat, that you get a commission. If you provide to the owner a list of who the people that you showed the boat to is. Now, the important thing here is that you want to protect the broker who showed the boat, right? And if the listing terminates and it goes to another broker and it's shown to someone that you already showed the boat to, we've created a mechanism so that the original showing broker can be protected.
That's an issue sometimes when you have someone who's switching brokers, moving from one broker to another. And in negotiating the listing agreement with a new broker, you have to be sure that you're excluding the people who are on the list of protected clients from the old broker. Another thing that we saw in the video was the seller said that he already had some presumably acquaintances or people who had expressed an interest in the boat, whom he wanted to exclude from the listing agreement, which is something that we see done fairly often.
Yeah, we do see that. What we know is that from time to time, the listing agreement is negotiated. And it's negotiated often by people who aren't really familiar with the yacht business. And it can happen with owners who might be in the building business and they sell a lot of property. And it can happen with lawyers who aren't familiar with the way it works as well. So we've standardized the mechanisms, and so the default protects the broker, right? Not to say that it can't be negotiated. Another issue that can be negotiated sometimes is what happens if there's a default and the deposit is there. Some sellers say, well, I want it all, but we've provided a mechanism that after expenses are paid, it's split 50-50 up to a maximum of the commission amount. So we don't have to argue about that. Sometimes somebody will want to negotiate that, but it's the ability to reference the standard in the industry as evidenced by this document that gives the broker a great deal of strength in that negotiation.
So you mentioned that on two issues. One, the fact that if it's forfeited, it's split 50-50, and two, that it's paid directly from the stakeholder or the escrow agent to the broker and not paid to the seller for distribution. On both of those issues, I think the EBA listing agreement dovetails nicely with the purchase agreement. But as you said, in the situation that you had, you're not always in control of what the purchase agreement looks like.
Right. You might have a situation where they're dealing with a MEBA, memorandum of sale or whatever they call it, and then the protections here are even more important because the purchase and sale agreement is designed to balance the rights of the buyer and seller in conventional fashion and a market-tested fashion, always keeping in mind the protection of the rights of the brokers. So it's important to use, in my opinion, an EBA listing agreement as much as possible, and in my experience with as few modifications as possible, if you want to preserve the certainty of getting your commission.
Now, we've talked about how the EBA listing agreement protects brokers, but obviously it's an agreement prepared for brokers. If you're representing a buyer who gives you the EBA agreement and says, how should I negotiate this? What kind of changes do you typically ask for?
Well, if you're representing a seller who's
Sorry, a seller.
Yeah. If you're representing a seller and they want changes to the agreement, you can make some changes to the agreement that would protect the seller. In my opinion, those changes tend to limit the marketability of the boat. They tend to limit the desire of a broker to be engaged with the boat. The most typical change that I've seen is a change where they want to limit the period for which the boat is listed for sale. And so they may want to say, I'll give it to you for 3 months, right? Whereas the standard is a year. Or they may want to say, I want to do it for 6 months. And it's really the law of supply and demand. If the broker thinks they can sell it within the time period, of course they go for it. And also you get a hook into a customer that possibly you didn't really have before. But I would say that's the biggest situation where I have seen negotiation. What about you, David? What situations have you seen?
Well, in addition to negotiating the term, we customarily go from, I'd say, 12 to 9 months or 6 months sometimes. A lot of it depends on sort of where you are in the boat show season and how many opportunities they're going to have to really market the boat. But in addition to the term, I would say we typically, the EBO agreement requires the owner to ask for a list of protected clients when the agreement expires. We shift that responsibility onto the broker to provide it, so that if they fail to provide that list, or if the list is incomplete, they're not entitled to a commission. Just provide some more certainty for the owner, and it's one fewer thing that they have to worry about. There are a fewer sort of more technical changes that we make with respect to indemnifications and reps and warranties about the condition of the vessel. But I would say the most significant ones are, as you said, to the term, to how protected clients are handled on the expiration of the contract. Sometimes we have people who, even though we explain to them that if you get an asking price that you're not happy, or I'm sorry, an offer price that you're not happy with, the commission is customarily negotiated down. They want to put that in writing. They want the agreement to say that if you accept an offer at anything other than the asking price, you'll have an opportunity to negotiate the commission. And I guess my view has been that that's sort of harmless, because that's something you would have anyway.
That's exactly right.
You have to explain to the broker why they want it in there, but it's really just a matter of meeting the client's expectations. But as you said, and as you mentioned in the video, if you negotiate a hard limit on the commission below 10%, that's something that they have to explain to any selling broker who wants to participate in the deal.
Or they need approval from their own brokerage house, right, to accept a reduced commission. So it's something, honestly, that I discourage my clients from asking for. If they say, what do you think? I think you want to sell the boat, accept the standard in the industry, and when push comes to shove and there's a contract on the table for less money, squeeze as hard as you want. But it's up to you. It's if you want to sell the boat, and it's up to them whether they want to earn the commission.
Trey, when someone signs a listing agreement, how frequently do you have owners come to you to sort of do their due diligence on any kind of duty issues before they sign a listing agreement?
Usually they'll come after the broker does tell them, hey, contact them because we do need to get your boat imported before I get this listing to go active. They may sign listing agreements, but they don't start any advertising until they actually get it imported. So we do get a lot of owners, but usually it's prompted by the broker.
Because the risk is that if you go active, you start advertising the boat, and the boat's not duty paid, at that point your only option, if you want to continue to market the boat in the U.S., is really to pay duty.
Right. Yeah. Well, it's either that or stick it in the foreign trade. So, whatever it is, you have to make it compliant at some,
right.
In one way or another, for sure.
And if you do sort of talk about your options before the boat's listed, marketed for sale, you can do things like a boat show bond or a foreign trade zone. You have more options.
Yep, absolutely.
And are there any sort of issues that you've seen that have come up with? What are the major issues you see with boat show bonds and foreign trade zones?
The boat show bonds, I would say, the biggest thing is the limiting factor of time, of time on the market to Americans. I guess they said in there, they're considering the Fort Lauderdale, Miami, and Palm Beach boat show, and they said the 15 days is the only time I can market it. The one good thing with that is if you show it to a ton of people, you can continue dealing with those people that you came in contact, that came in contact with the boat at the show itself for that period of 6 months that the bond is active. But other than that, there's not a ton of drawbacks to it other than having to get out of here by a certain date. We've had a few boats that ended up with catastrophic failures of a motor, or had to cut a big hole in the side of the boat because of a fuel tank, and they couldn't leave. And then at that point, they're forced to pay the duty, because you have to close this boat show bond, whether it's leaving or paying the duty. But there are no extensions on them. So, and if you don't pay, if you don't get the required closing of that bond done timely, then Customs charges you double the duty as a penalty. And typically, you're paying a penalty, you're not paying the duty. So you may end up paying, in this case, 3%, which is what a boat show bond is, 3% of the boat's value as a penalty, and still not have a duty paid boat. So those could be some of the drawbacks. I've never seen it go to that. We've never had a boat that's actually been issued a penalty because we always make sure that we get them out of here timely, or at least pay the duty timely. But that's really the drawback there. And I guess like with the foreign trade zone, the drawback is, the owner really can't use the boat at all. And there's the cost, the continued cost associated with being in a zone. It's, some people call it a free trade zone. They're not exactly free, but they are a nice addition to yacht brokerages and being able to sell boats.
Yeah, I say that those are the two drawbacks. You can't use the boat, and it costs more money to be in there.
Mm-hmm.
However, what we've found is that the strategic use of a free trade zone makes a lot of sense.
Yeah.
In other words, if you've got the deal kind of lined up,
Mm-hmm.
and then you're not going to be in the free trade zone that long. Now, they want you to stay. The contracts require you to, if you're going to go in, you've got to pay dockage for X amount of time.
Mm-hmm.
But in the context of the deals that we see, paying the extra dockage is almost irrelevant,
Sure.
right, to the savings that are achieved.
Yeah, in those cases where, someone may put a deal together while the boat's sitting in Nassau, and they want to do the surveying and all that, they bring it here, they put it in a zone, then they can legally do all they need to do and even close on it there. So,
Right, and if the boat's out of commission, so to speak, for a week,
month,
2 weeks,
yeah.
3 weeks, a month, who cares? You get a lot of other stuff done
Sure.
during that period.
Yep.
When the foreign trade zones first sort of became a thing, I guess I didn't immediately see the appeal because, both like a boat show bond, the owner can't use the boat, which is a drawback, but also the requirement that when you leave the foreign trade zone, you either pay duty or immediately clear out and go foreign. I guess my thinking was, if you have to go over to the Bahamas anyway, after leaving a foreign trade zone, why don't you just close in Nassau to begin with, or in Freeport or Bimini or wherever to begin with. But brokers have really done an amazing job of showing the boats at the foreign trade zones and driving new
Mm-hmm.
buyers to the boats, and it really has. We've been seeing more and more closings taking place, more and more owners putting their boats in foreign trade zones as an alternative to the boat show bond. The issue we see, I would say, most often with boat show bonds is you mentioned that you can show it to outside of the show to U.S. buyers who were shown it during the show.
Right.
But record keeping is a big deal.
Sure. And it's never been tested, really. There's never been there's no standard for, what's a record that would hold up? Is it a broker going, John Smith and his wife came? It just, that has never been tested. It's never been requested by customs either to do that. But we always just say, keep the best paper trail you can. So if it does become an issue, how are you showing it to this person? Say, well, they came to the boat show. We looked at the boat, and you can't just buy. It's not like buying a cheeseburger. You can't just do it in a day. It takes time.
Well, it's interesting because it correlates to the record keeping requirement that you'd want to be entitled to a commission,
Mm-hmm.
right? You want to make sure, and some brokers
Makes sense, sure.
have historically not done that. Everything's just done on the phone. If you do everything on the phone, you're not going to get your commission, right? If you evidence it with a trail of emails,
Mm-hmm.
preserve your text messages, even preserve, if necessary, your phone records, right? All of that stuff comes into play big time with commission disputes. And there's a lot of money at stake here too if you want to not pay the duty on a big boat. So keep your records, but just in the normal course of things, and don't take anything for granted.
Yeah, I guess the fear is that you have a broker who comes on a boat at the show and says he's representing 3 people who in fact he hasn't talked to about this boat,
Mm-hmm.
and then wants to show it to them outside of the show, and there's a risk at least that you've violated the terms of your boat show bond. And so we have some owners who are especially cautious and make any brokers who come on board sign a certification saying, I'm here on behalf of these clients, and I indemnify you against liability for duty if I'm lying, which is definitely a cautious approach. But when you're talking about potentially 3% of the boat's value,
Sure, yeah.
and still not getting duty paid.
Right, and it's really minimal effort to cover yourself too. It's not that much, going over and above. Effort to get that, kind of, backup in place. So I've never heard of anyone doing that as far as you guys have, but that's interesting and smart way to do it.
Well, I love that because that's
makes sense.
the highest standard in the practice of law. So I don't know if it was your idea, but it's a great one. I just stole it.
So are there any other issues when a client comes to you and says, I want to sell my boat, here's my listing agreement, here's a broker I'm working with. What sort of things do you think it's important to talk to them about, just generally?
Well, ultimately, the question that comes to my mind is the quality of the brokerage house, really, and so that's a difficult one, but because it's really a business opinion, right? You're being asked. So here's the listing agreement, and this is the brokerage house, and I'm selling X type of boat, and this brokerage house is located in Y location. And so I would say that really the questions turn not to be legal. They turn to be more commercial. And I guess when customers hire lawyers, they're not necessarily just looking for their legal advice. There's added value to hiring a lawyer who knows what the industry is about and what the non-legal risks are, right? So I would say that's more of the issues that we think about. Now, it's logically, there's a certain type of boat that's going to fit better with a certain type of brokerage, or a certain type, not with a specific broker, but with a certain type of brokerage house, right?
One of the things that I think is very good about the yacht industry in Florida is that the brokers are regulated professionals. And so when you're dealing with them, when they're holding money in a deal, it's like dealing with lawyers in another country where you know that they have something to lose. You're dealing with someone who's a regulated professional, licensed by the state, and you don't have to trust them to be a good person all the time. You just have to trust them to be self-interested and not want to lose their license. And to me, obviously it's better when you're dealing with somebody you trust and respect professionally, but even the fact that brokers are licensed, I think, gives me some comfort.
Yeah, it does. Now, I would say, getting to your original question about issues that you deal with, in certain situations, we will strongly recommend that escrow deposits be held in specific situations. In other words, if you're doing a big boat deal, right, you want the deposit held in the safest place possible, right? If you represent a buyer, if it's an established brokerage house, you got no problem having the money held there. But what if it isn't, right? What if it isn't? Or what if there's a proviso, somebody wants to, in a purchase agreement, have the escrow held by a small law firm. We're not that big of a law firm. You aren't that big of a law firm, but we have, a reputation of, tens and tens of decades of reputation. So it's going to be harder for us to steal $1 million in escrow and go to Brazil, right? But it's part of this non-legal advice that we give about where deposits should be held. So
it's always nice when you're dealing with somebody you deal with often and you can really trust, because for example, if we're doing a deal in Europe and on the other side is a law firm who we work with frequently and know well, if we're representing the buyer, sometimes to facilitate closing, we'll just send the whole purchase price there a few days before closing to hold to our order. And it's always good when you have sort of an international deal to have the money be in the same place where the closing is going to happen time zone wise, because otherwise you can be sitting around waiting on a wire. So it is really nice when you're dealing with somebody you trust and you can make sort of accommodations like that so a deal goes more smoothly.
Yeah.
Bob, one of the things we were talking about was the changes that you make to the EBA listing agreement. Now, sort of mechanically, there's a couple of different ways you can make changes. You can either write them in or you can do a separate addendum. What do you think about the best way to make changes to the agreement?
Well, one thing that you absolutely don't want to do is take the agreement, put it in Word, and then put your own words into it. That's a disaster for a lot of reasons, but mostly because the form with this IYBA logo on it creates an expectation of what the duties of the people are. And if you change it in there, you're almost, it's almost fraudulent. And you don't want to get into a mess like that. And so there's two other ways to handle this. One is if the change is small, you might write a line through it and initial it, and you might write something in underneath and initial it. However, if there are going to be any significant changes, the most elegant way, and I don't mean that in the sense of dressing it up nicely, I mean the way to achieve clarity is to essentially leave the form as it is and write an addendum to it. You can usually write that addendum in a page so that the other person reviewing it, all they have to do is look at the addendum to see what the differences are.
Yeah, I think that's, people in our industry are so familiar with the forms that it's not difficult for them to look at an addendum and know that's what these changes are. These are the changes we're making.
And it avoids getting a document that's all marked up, and these documents go back and forth via, they're scanned and emailed or whatever. And it makes everything clean and easy to understand.
Mm-hmm. No, I agree. I think the best practice is definitely to have a separate addendum, particularly when you're dealing with a form agreement like this. All right. Well, Bob, thank you very much for coming. I appreciate your time.
Thank you.
Trey, thank you for coming.
Thank you.
We're going to take a break, and that's going to be followed by Act 2 of As the Prop Turns, and then I will be back with a new panel to discuss the issues raised in Act 2. Thank you.
We would like to extend a very special thank you to our friends over at Alley Moss, Rogers & Lindsay, PA, for their continued support of Yacht Sales the Law. This 25th edition wouldn't be possible without their generous endorsement over the years.
Maritime arbitration has been around for hundreds of years. Now we have a new forum to solve our disputes. The IYBA has created the International Yacht Arbitration Council to solve our disagreements. We have experienced maritime attorneys and yacht brokers to serve on our panels, people who know the law, who know boats, and who know the yacht business. IYAC arbitration can handle yacht claims, contract, purchase, and commission disputes privately, quickly, and less costly than going to court. Sometimes disputes happen, and when they do, the IYAC is here to help you solve them.
Hey, baby. Yeah, Daisy, it's me. Hey, I'm on my way back down the boat to see if these fellas are doing any work like they're supposed to. Hey, I just got done having lunch with Chad and your cousin Buffy. Lord, honey, I mean to tell you, this is going to be good. He wants to spend $3 million on a new boat. Yeah, he's getting some kind of bonus because, he's a fancy stockbroker or investment fellow. I don't know exactly what he does, but he's making a ton of money. He's supposed to get some great big bonus, and he says there's a thing called, some sort of depreciation, that if he buys something, he can write it off and save a whole bunch of tax money on this boat. Yeah, well, your cousin, she loves them Italian boats, and she's just crazy about that boat that was in that George Clooney movie. Yeah, darling, that's right. That's the boat that Frank works on. That's right. Yeah, and if I'm not mistaken, they're asking something just a little north of $3 million, and that's what Chad wants to spend. So, baby, this might be just a match made in heaven. For the first time, honey, I think our ship has come in and we are not at the train station. This is going to be awesome. Yeah, so, well, there's all kinds of complicated stuff about this. Something about foreign flags. So, I don't know, we'll figure that stuff out. They got bareboat charter he was asking me about. Now, I'm not quite sure what all that means, but he apparently has him a charter all set up for Christmas time, and you got to do a charter in order to get this sort of depreciation thing he was talking about. Baby, I don't know. It's all so far above my head, I'm really not 100% sure. I don't know nothing about that stuff. I'm hoping that other broker on the other side of this deal. Speaking of brokers, I'm gonna have to call Paulie, and I'm gonna have to get him to sign me up for a broker's license tomorrow morning. Yeah, Well, hell yeah, I can get it, honey. All you need is $500 in a pulse. Shit, ain't nothing to that. Right? Yeah. No, baby, I'm telling you right now, this is a game changer. Yeah, so one of the things that Chad was asking me about is foreign captains. Apparently, I guess he can get him a better deal if he uses a foreign captain. So I told him, ain't no problem. It don't matter who drives a damn boat. As long as the guy don't bang into nothing, who cares? Right. And he asked me about lawyers and stuff. I told him, I said, there ain't no need to get a lawyer in the middle of all this, but you know, sometimes these big highfalutin fellers, they want to get lawyers in, so we'll just let him talk to Laura. I don't care. Whatever works for him works for me. Well, that's all I know for right now. Okay, we're going to get the details worked out. Let me see if these fellas is working on the boat. No, nobody here, as usual. Damn. All right, I love you, baby. Bye. I'm going to call my buddy Frank. I'm going to figure out a little bit more about that boat, and I'm going to call that broker, and I'm going to make me some money. I'm a yacht broker now. Here we go. Hey, Frank. Frank? Bubba Calhoun, how you doing? Hey, man. Yeah, no, it's all good. It's all good. Hey, tell me a little bit about that Limone that you're driving. That thing's for sale, right? Uh-huh. Yeah, he's asking too much. Well, anybody told him yet that it's overpriced? Okay, all right. Well, who is that broker? Bill Boatwise? That's a real name? Okay, all right. Well, I'll call him up. All right. Hey, shoot me over his contact information. Let me give him a shout. I know you got it. All right, buddy. Thanks, man. All right, be good. Bye. We're moving now. We get where we need to be. I might have to get me a haircut one of these days soon. Say, them fellas is thinking they were 3.8 $3.8 million.
Good morning.
Yeah, can I talk to Bill Boatwise, please? Is he in?
Yes, I'll put you through.
Okay, all right, thank you.
Bill Boatwise, how can I help you today?
Hey, Bill. Bill, my name's Bubba Calhoun out of Brunswick, Georgia. How are you?
Yeah, hey Bubba. How are you today?
Oh, I'm good, man. I'm good. I'm fine, thank you. Hey, listen, I'm kind of new to brokering, but I've got some folks that I've been working with known them a long time. I've known these folks forever and a day. Fella who's actually, you know, being at the end of the year, they get identifying their bonuses and all, and this fella's come in with a lot of money, and he wants to buy him a boat. Apparently, you got the boat listed that he wants.
Oh, really?
Yeah.
And what particular boat are you talking about, Bubba?
Yeah, it's an 88-foot Limone called Spicy Meatball.
Yes, the 88-foot Limone. Spicy Meatball. It's a fun name, isn't it?
Yeah, right. Who did name that boat? I don't know. Anyway, who cares what it's named? We're going to name it something else soon. Yeah, buddy. Look, my guy, he wants to make a deal. He wants to make a deal soon. He needs to close fairly quick. And I know your asking price is a little bit high, but he authorized me to make an offer of $2.6 million.
Okay. Well, that's a little lower than we were hoping for, but I suppose if you want to present the offer, you're more than welcome to.
Well, you may think it's low. That's a lot of money, fella.
Yeah, I understand that you think it's slow, but it's still not going to get the deal done. But again, we can present the offer and see where it goes.
Yeah. No, I get it. All right. Well, look, you know, can you just go ahead and present that to the guy who owns the boat and see if we can get something going here?
No, Bubba. I'm going to need an offer like this. I'm going to need this in writing.
Oh, you need it in writing? Yeah. Okay. Sure. I can get something in writing. I have to go back and see my client.
So, Bubba, I trust you're going to use the approved IYBA purchase and sale agreement, correct?
No, I don't know nothing about no IYBA form? No, I don't know nothing about that stuff.
Well, we'll tell you what, Bubba, why don't we do this? Why don't I send you the form so you have the template, you can fill it out and get it signed by your customer.
You can, so you're authorized to use that form?
That's correct. I'm authorized to use the form.
Okay, can you send it over to me? So I'll just go ahead and fill it out?
Yeah, sure, Bubba. Sure, I can send you the form, no problem.
If I have any problem, can you help me with it? Yeah, okay, all right, all right. All right, well, shoot it on over to me, and I'll get my fellow to sign it, and there's something about a deposit. Yeah, you...
That's correct.
You need...
Upon execution of an agreed upon price, we will need a deposit of 10% of the agreed upon price in escrow.
Right. Okay. All right, Bill. I look forward to doing business with you, man.
Okay, Bubba. I'll wait to hear back from you.
Thanks. Bye.
All right, let's give Mr. Ficarino a call here. Mr. Ficarino, how are you today, sir? Well, listen, I have some good news. I have an offer on your boat. It's not at full price like you'd like it to be, but it is still a pretty competitive offer. We have an offer here at $2.6 million. Jeez. Oh my God. All right, slow down. Jesus. Listen, Mr. Ficarino, I know it's not at the number that you were hoping for. However, listen, it's not the number that we're hoping for, but I think that it's a good opening offer. Even though it's a low offer, it's still an offer. It's something that we can work with. Let's see what we can get this buyer to. We've had the boat listed. I don't think he's wasting time, Mr. Ficarino. We've had the boat listed for 6 months now. It's a real offer. Let's see what we can do to get this buyer up. I don't want to lose this deal. I don't want to lose this guy. So let's see what we can get him up to. And my experience is that the first offer we get is generally the best. So let's work with it. Let's see what we can get this guy up to. Okay, so 3.1 is your counter and is also your bottom number. That's it. That's going to put you at about a 2.8 net. Are you comfortable with that net, Mr. Ficarino? Well, following an executed purchase and sales agreement, we should expect a deposit. And 2 weeks after that, roughly, whenever we can have surveyors available, they will want to survey and sea trial the boat. If there's a problem, then we renegotiate following the survey. Yeah, so what I'm going to do is I'm going to call the buyer's broker, and I'm going to relay the 3.1 counter to the broker. And once we have a fully executed purchase and sales agreement, I'll forward it to you for your review. All right, Mr. Ficarino, we'll be in touch. All right, time to I'm gonna call Bubba. Mouth breather. Bubba, good afternoon. How are you?
Well, hi, Bill Boatwise. How are you?
Well, listen, I have a counter from my client. The absolute lowest he's going to go is 3.1 million. I'm telling you that he's at the end of his rope.
Yeah, all right. So he's at 3.1. Well, Bill, I got to tell you the truth. Chad told me the absolute max kind of money he's got is $3 million.
Okay, so you're telling me your client is at 3 million max. My client is absolutely done at 3.1 million, which is going to give us a 2.8 net.
So 3.1 equals 2.8. Yeah, okay, if you say so.
Bubba, we have a 200 grand here that we need to fill the gap. Are you willing? This is not something that I like to do or ever do often. But if your client is at the end of his rope and I can't get my client down anymore, the only way to make this deal happen is to cut our commissions. Are you willing to work with us here and cut your commissions a little bit to make this deal happen?
Yeah. I think I could get that done.
All right, so you're willing to do what you got to do to make this deal happen. Listen, again, it's not something I'm happy about doing or normally do, but let me talk to my team and see if we can get this type of commission cut approved, and we'll see if we can get this deal done.
Okay, Bill. All right, Bill, do me a favor. Hey, you got another one of them forms, that PDF thing you was talking about? I can't seem to find that last one. I'll fill out a new one, have Chad sign her up. All right, feller, thanks a lot. See ya.
All right. Thanks, Bubba.
Welcome back to Yacht Sales and the Law. We're going to spend some time now talking about the issues that were raised in Act 2 of As the Prop Turns. I have here with me returning Bob Allen, Robert Allen Law, and Jeff Stanley, Gilman Yachts, also an EVA board member. And we're going to spend some time talking about the issues from Act 2. Now, Jeff, the first question I want to ask you, now that we've been introduced to Bubba Calhoun, is do you have any concerns from the standpoint of professionalism about Bubba Calhoun?
I would like to hire him if he was available. But no, Bubba is probably a role model for someone you may not want to hire as a licensed Florida yacht broker. As far as I can see from the video, he's not yet licensed, which is maybe where he should start.
Okay.
He's definitely playing fast and loose with every facet of a boat sale.
And speaking of licensing, Bob, what can you tell us about how yacht brokers are licensed and regulated in the state of Florida?
Well, not a whole lot, in the sense that there's not a whole lot of regulation. You pay a fee, you get a piece of paper, and you go to work. And that's basically how it works. You get a bond, but the bond is minimal. In other words, when people think of being bonded, of dealing with someone bonded, they think they have real protection, right? But the bonding limits for a salesman and for a broker in Florida are just absolutely minimal. I think they're $10,000 and $25,000 respectively. And what does that mean? It means that customers think they're dealing with someone who is highly regulated. They are regulated, but the financial implications of a salesman or a broker not dealing with you in accordance with the requirements of law are not that strong anyway. So it would be a worthwhile endeavor, I think, for the people of the state of Florida for that regulatory framework to be strengthened. I'm generally not a believer in regulations. I like self-regulation. But the truth is that brokerage houses and brokers and salesmen, they deal with things that are worth hundreds of thousands and millions of dollars. And they need to be dealing with serious people. And the state of Florida and all states, I think, regulate real estate brokers in a much more stringent and detailed way. And again, I'm not totally into hyper-regulation, but there's a lot of money at stake, and the future of the industry is at stake if you're dealing with people who are less than honorable as brokers.
And under what circumstances does someone need a license to act as a broker in Florida?
When there's a boat in Florida and you're talking to somebody about buying it. When there's a boat in Florida and you're talking to someone about offering you a listing agreement, the right to sell the boat. Essentially, if you're trying to sell a boat that's in Florida, you should be licensed. And by trying, I mean getting a piece of paper that allows you to, or taking someone to the boat and really talking to somebody about the boat. You should be licensed. That doesn't mean you can't refer someone to a broker that you know and get paid a referral fee, as long as you're not undertaking the activities that a broker would undertake.
I think the law says in expectation of a commission, right?
That's correct.
Yeah.
And Jeff Bubba mentioned that he was going to go get a license, but if he wanted to apply for a license in Florida, he couldn't just get one on his own. Is that right?
No, he would have to work under a broker, and he'd have to find someone to hire him. It won't be me. I was kidding about that. But in reality, he would be able to find someone to hire him when he walks in with a deal in today's climate.
And when you're on a deal and there's a broker from out of state who's participating, how does that issue play out?
Well, a broker who anticipates a commission in the state of Florida needs to be licensed in the state of Florida. There's the enforcement of that seems to have gone up and down with the person in charge of the department. And there are times when it's been rigidly enforced, and there are times, like I believe right now, where it isn't. But we could all do better with some clarification of that law.
And of course, there are exceptions. I think it only applies to boats that are over 79 feet but under 300 gross tons. So the very largest boats, you actually don't need a license. And I suppose the theory is that people who are substantial enough to be buying boats like that are able to protect themselves. And so the licensing really is a consumer protection measure, and that's why it's important to sort of regulate the mid-market. One of the things that Bubba mentioned as he was sort of filling in the blanks on the EBA purchase agreement was survey and a timeline for survey. In a perfect world, what sort of timeline do you like for survey, sea trial, acceptance, and then closing?
It really depends on the size of the vessel. Let's say it's a 50-foot boat. You could, in a normal business climate, put 2 weeks to survey and another week or two to close. We're not in a normal business climate, and this year you'll have a hard time finding the right surveyor to commit to survey, review the survey, and accept the vessel in a 2-week period. And it's just a 50-meter boat, it's a whole other story, because the surveyors you're going to use on a large boat are typically surveying a 50-meter boat for 3, 4, 5 days, and you're not going to get the right person in a 2-week period.
And then they take another week to generate the report.
Exactly.
You have engine oil samples and all kinds of stuff.
Exactly.
Yeah, I think the more time you can have before acceptance, the better.
I would say 30 days to accept a larger boat today is probably a little more accurate, and I think a good broker is in touch with his surveyors and also knows what's going on with them. I mean, I oftentimes will call a surveyor, make sure they're available before I set my dates, and go from there. Keep the dates as tight as you can.
In fact, on a big boat, you might have different surveying teams, people looking at different aspects of the big boat. So you've got to coordinate them. And these days, talking about not normal times, and you're talking about a bigger boat, if it's in Europe, arranging for surveying of boats in Europe is not an easy deal, right? So you've got to build in enough time.
And I think for most people would say the rule of thumb for acceptance to closing is at least a week.
Yeah, especially with a foreign flag boat where you've got, just getting an abstract or a register out of places like the BVIs. You don't get it in a day or two.
And one of the things that we see as sort of a determining factor in the timing of closing after acceptance is, representing a buyer, we don't like to set up a company before we've accepted the boat, because then if you reject the boat, you have this company you have no need for. And so generally you set up the owning entity after acceptance, and depending on the jurisdiction, that can take a few days. And particularly when it's an offshore boat, an offshore owner with a foreign registration. One of the things that Bubba mentioned that I want to talk about a little bit is bonus depreciation and chartering. I'm going to say as little about bonus depreciation as possible because I'm not a tax lawyer, and I strongly suggest that anyone considering that hire a tax lawyer. But one thing that I do know about it is that to take advantage of that, you have to charter the vessel. She has to be used in a trade or business. And in this case, the vessel is foreign built, foreign flagged, so your options for chartering, particularly in U.S. waters, are limited. He mentioned bareboat charters. Bareboat charters under maritime law involve the complete transfer of possession, command, and navigation of the vessel from the owner to the charterer. The charterer becomes, in effect, the vessel's temporary owner. And the way this is accomplished in the yacht world is you have separate agreements with an entity that owns the vessel and an entity that employs the crew. So you're signing an agreement for the use of the vessel, and then you're signing a separate agreement for the services of the crew to operate the vessel during the charter. And that's sort of become an industry standard practice, but it's something that Coast Guard and CBP have historically regarded with a degree of skepticism. And we always have to warn our clients that however careful you are about observing the form of a bareboat charter, it is always possible that it will be recharacterized as a time charter. And if it's a time charter, then suddenly you're carrying passengers, charter guests, in violation of the coastwise laws. And that can be a serious infraction. That can be anywhere from, I think, $700 or $800 per passenger up to forfeiture of the vessel. And we've never seen that happen, but we have to warn clients that that's something that the Coast Guard could do. They could seize the vessel. Now, this vessel we said was foreign built, foreign flagged. Could he document the boat in the US and charter the boat on a time charter basis? The challenge here is that the boat is foreign built, and generally coastwise endorsements are only available to US hulls. Because I believe the boat is more than 3 years old, he could get a MARAD waiver from the build requirement and then document the boat in the US, get a coastwise endorsement, and in theory be able to charter. One problem is that he would only be able to charter on a time charter basis in the US, because if the boat is over 79 feet, she needs a load line certificate, which you can't get from the Coast Guard, which means she couldn't charter on a time charter basis in the Caribbean, for example. So you'd still have to use a bareboat charter. So oftentimes when clients come to us talking about how they want to document their boat in the US because it'll make it easier to charter, that can be done, but it's generally only true in the US, especially on larger boats. If you want to charter outside the US, you have to continue to use a bareboat charter and all the sort of extra complications and risks that come with that. So the last...
I wanted to ask you something. How hard is it to get a MARAD waiver?
In my experience, they're more or less automatic. The process is you file an application with MARAD, they publish it in the Federal Register, and then there's a 30-day notice period or comment period. And if nobody comes back with a comment, they'll issue it. The only sort of decision you have to make is, one of the things in the application is, where do you intend to use the vessel? Where's the vessel going to carry passengers? And you can't just say all states or all waters. You have to say, you know, Florida, Georgia, et cetera. And I've gotten them to approve them all up and down the East Coast or for all along the Gulf Coast. Occasionally they will come back and say they want specific exemptions. You know, because the theory behind the MARAD waiver is that it's only supposed to apply if there is no capacity among US built vessels to serve that need. And so if there's a US built passenger carrier operating in a specific area, sometimes they'll want to exclude that from the waiver. But it's generally in places where people don't charter yachts, so it's not a problem.
Have you ever had an objection or a comment?
I have never gotten a comment on a MARAD waiver. In my experience, what I have had is the MARAD personnel have come back to me and said, would you put in this or that exception? And I suspect that's to sort of head off an objection that they know is coming from someone. But I've never had someone comment on a MARAD waiver. And one important thing to note about the MARAD waiver is some people think that the MARAD waiver is the same thing as a coastwise endorsement. So once you get the MARAD waiver, you're good to charter. And that's not true, because the MARAD waiver is only a waiver from the US build requirement. There are other requirements that apply for a coastwise endorsement. For example, the vessel has to be at least 75% US owned. So really, for most people, it's a two-step process where you apply for the waiver, you get the waiver, and then you have to apply for the coastwise endorsement and get a new certificate of documentation with that endorsement. And that whole process can take months.
And the problem I see is that when you're buying a boat, all of that is unknown whether you'll get it.
Right.
So you have to choose which direction you're going to go with your flag, because there's no guarantee.
The one other thing with the MARAD waiver that's less of an issue is, if the boat has ever gone foreign, has ever been foreign flagged, in theory, she's not eligible for a MARAD waiver. However, they have waived that for vessels up to 200 gross tons, which means if you have a boat that's over 200 gross tons and has ever been foreign flagged, she can't get a MARAD waiver. The only thing you can do is an act of Congress. So that's definitely something, it's relatively rare to find a boat that's sort of in that category, but it's something you have to be aware of because it affects the value of the boat, because it affects your ability to register the boat in the U.S.
I actually had an act of Congress.
Really?
I did. It was probably, the boat was right here at Pier 66. It was probably 30 years ago, and it was owned by a German, and the next guy wanted to charter it. And the buyer knew somebody, got it tacked on a bill. 2 months later, it was done. It's just probably wouldn't happen today.
It's amazing. There's some dark corners of the U.S. code where there's just names of boats tucked away.
Yeah.
The last thing I wanted to talk about was the foreign captain that he mentioned. Now, Jeff, first of all, why would somebody want to hire a foreign captain?
In my experience, they are possibly a little more negotiable in their remuneration, because they do have some limitations to where they can work. And we have a pretty big influx of captains from South Africa, from France. So there are possibly more foreign captains in our jobs.
And historically, have they been able to work on U.S. documented vessels?
To my knowledge, not legally.
Yeah, but some do.
They do, not legally.
Right. So until recently, the rule for, it was actually a visa issue. The B-1 visa only applied for crew on foreign flagged yachts. But recently there was a change to the Foreign Affairs Manual, which is sort of the guidebook for consular officials who issue these visas. And this change was made late last year, but we had a hard time getting sort of an official opinion on it from CBP. But recently we met with CBP and got sort of informal guidance, which is going to be followed by a more formal guidance, that in fact now the change means that you can have foreign crew on U.S. documented vessels if the vessels are used both in U.S. and foreign waters, which would obviously be a great benefit for our industry and remove one of the major obstacles or major drawbacks to U.S. documentation. Now, if they wanted to charter the boat, the fact that you can get a visa is definitely not the end of the story, because as a U.S. documented vessel, when you're chartering, there could be Coast Guard credentials that you need that are only available to citizens. In addition, there's a statute that says the captain of a U.S. documented boat has to be a citizen unless the boat has only a recreational endorsement. So if you go through that whole process of getting the waiver and getting the coastwise endorsement, that means you can't hire a foreign captain, even though the captain would be able to get a visa. But my understanding is that a lot of people are looking forward to being able to hire foreign crew on U.S. documented vessels at more junior levels, that they still expect the senior officers, because of the credentialing requirements, that they'll continue to be U.S. citizens. It's always difficult sort of when you're talking to a client up front about all of these rules and how they're going to affect your ability to use the boat. Because he has plans, in this case he wants to charter to take advantage of bonus depreciation, but they may want to charter in the U.S., they may not want to worry about a bareboat charter. Jeff, how do you manage those expectations, or how do you guide people through that process?
That's a very good term, managing expectations. That's, I think, most of what we should be doing as brokers. The quick answer is to put them in touch with either one of you gentlemen or another qualified maritime attorney, because, for instance, your recent meetings with the Customs and Border Protection, I knew nothing of that, and that's could be a game changer. So you can't know all facets of the business. Sometimes you have to defer.
And that, I think, is an important aspect of what we were talking about earlier, the professionalism, which is staying in your lane, knowing what you're responsible for, and when you need to bring in somebody with some expertise in another area.
Absolutely.
And that applies in particular to the tax issues, right? Because there's a tremendous amount of discussion going on right now about bonus depreciation and how you qualify and how you don't, and that boats are going to be easier to sell and all that kind of stuff. There are rules that are attached to any type of advantage that you derive when you're dealing with the IRS that are kind of tricky, and you're best guided through that by getting a tax lawyer or an accountant who's familiar with depreciation as well. My own fear, And maybe it's not a fear because it'll lead to more work for people like you and me, particular tax specialists, is that people are going to think that they can do something with these rules and then find out that the limitations on personal use are such that they exceeded them, and then at some point, if it gets to be something that's in style, so to speak, the IRS will start coming after rich boat owners who took accelerated depreciation when they shouldn't have. So it's something to be very careful with.
It can be difficult. I mean, in my experience, it can be difficult to sort of separate the tax issues you're advising on from the ones you're not. Because, for example, we often advise on liability for sales tax,
Right.
sales and use tax in Florida. But I actually put in my engagement letter that I do not advise on federal income tax. That's just something that's not in my area of expertise.
Well, actually, that's a brilliant suggestion, and it will be the second suggestion that you've made today that I will steal from you.
Excellent. All right, well, thank you both for your time. I appreciate your being here, Bob and Jeff. We're going to take a break now, and when we come back, we'll have Act 3 of As the Prop Turns, and then I will be back with a new panel to discuss the issues raised in Act 3.
IYBA would like to thank Yacht World for their support of this year's 25th Annual Yacht Sales and the Law.
All right, we got a contract. Let's see if we can get this thing done.
All right, Chad. God damn. Chad. This here survey don't look so good. This boat been aground and maybe even had a engine room failure. Fire. Not damn fire. Whew. Seriously. Oh man, $100,000 discount. Chad, you're gonna have to be more realistic than that. That's a lot of money. Okay, I'll send the conditional acceptance, but you and me know the truth. I'll keep, misspelled that. I'll keep it close to my, I know, I'll keep it under my hat. I'll keep it under my hat. There's room in there. Okay, all right. Man, we might actually get this daggum thing done. All right.
Welcome back to Yacht Sales and the Law. We've just seen Act 3 of As the Prop Turns, and I'm here with another panel to talk about some of the issues that were raised in that act. I have here Michael Moore from Moore & Company, a lawyer well known to all, and Nancy Poppy from Willis Towers Watson, insurance broker. We're going to be talking about some of the issues that arose specifically in relation to the survey and moving toward acceptance. So the first thing I wanted to talk about, Nancy, was sort of the insurance implications. You know, we got these very bad results in the survey. And what does that mean in terms of the buyers trying to find insurance?
Well, the buyer should have already been in contact with an insurance broker, his insurance broker, and started to lay the groundwork for the plan to get insurance, because it's more difficult these days than it has been in years past. But a poor survey will mean a lot of scrutiny from all of the underwriters, insurance underwriters, and they will want to know, most importantly, what is the buyer going to do to remedy the defects, and whether it's the seller, as we saw, Chad was requiring that the seller or fix everything, if that's the case, or whether the buyer is going to do it. The plan needs to be clear and apparent to every insurance underwriter, and that would include who's doing it, what's being done, where they're going to do it, what shipyard they're going to do it in, when they're going to do it. It's no longer good enough just to say, well, we're going to buy the boat and then we'll figure it out, or we'll just do the stuff with the star next to it in the beginning and then we'll do the rest 6 months later. So that doesn't fly any longer. And with a poor survey, it probably will knock out some underwriters from the playing field.
And in this case, Chad had asked the seller to have some of the work done before closing. You mentioned that the insurers are going to want approval on how all that's done. And when it's done, are they fine having the original surveyor sign off on all the work?
Yes, they are fine having the original surveyor sign off on all the work. But what we find is there's a difference of language between the survey recommendations and what will be done. Insurance companies want to know that all recommendations will be done, and that's all. We find that buyers and their teams tend to gloss over some of the less, what they consider less important safety-wise and more cosmetic, and they'll say, well, we're going to do these. Well, you've hired a surveyor to tell you every single thing that's wrong with the boat, and now you kind of have to go with it. And so if the surveyor says that something is wrong with the boat and you're saying we're not going to fix it because we don't think it's important, you really need the surveyor to agree with you that, okay, that can be deferred for the next period.
So if it is purely cosmetic, not a safety issue, you can get the surveyor to say,
you can defer that,
yeah.
Right? But the surveyor is the expert you've hired to give a condition report on the boat, and so for everyone else to weigh in on what they think or when they're going to do things really just complicates matters. Just have the surveyor be the driving point of the information, and then I think everyone feels more comfortable, including the underwriters, who are the most important.
And you mentioned that it's becoming harder to place insurance on these boats. Can you tell us a little bit more about sort of how the market looks and how it's changed?
Well, yes, and probably everyone's heard this a million times now over the last few years, but we're seeing kind of the impact of it still today. 2012, 13, 14, 15, 16 were the lowest premiums historically in really anyone in my peer group's memory. And so prices were cheap. Premium, insurance was cheap. And then hurricanes in 2017, a number of losses followed there along, and so you had very cheap prices for the last 5 years. and the insurance companies' coffers were not as full. Then you had a large number of losses. Really, the windstorm, 3 claims in 2017 kind of kicked off things, but there were a number following that. And so insurance companies started to look and say, why are we doing this class of business? You know, our premiums are this, and the chance of loss is this, these very expensive boats. So in about a year's time, 50% or so of the capacity the insurance companies or underwriters in the world pulled out of the class. That reduced supply. At the same time, they identified that their prices were too low. People actually underwriters lost their jobs because they had been allowed to kind of have free rein, and suddenly they were the cause of this, problem that we were facing. So they said, insurance companies said, we're going to increase our prices. Some insurance companies pulled out, reducing supply. And then that gave kind of the remaining insurance companies an opportunity to start truly underwriting again, going back to the things that they felt and knew were important to being successful in the business, but had to maybe let go or become more relaxed on because it was so competitive. So if they wouldn't agree to something, someone else would. And so all that, in a big bucket means you really need to present yourself as a good insured. Work early with your broker. Don't wait until a couple of days before closing and then show up with a bad survey. Your playing field is more limited, and your ability to, again, present a good story and have your broker present you in the marketplace and get you a lot of good options is compromised if you don't plan ahead. So we like to say at the time of the thought of a purchase, when the yacht broker's starting to talk about, okay, we're seriously going to hone in on this one, even before the survey's done, that's the time to start talking to an insurance broker.
And certainly before acceptance. You don't want to find out after acceptance the boat's uninsurable.
Right. And that's happened so many times, David. I mean, we get these calls, and some of my peers in the industry, sorry to cut you off, but it's a time unlike any other where there are boats that now will not be able to get insurance.
And we've seen that not only with boats that are uninsurable, but with first-time buyers who find out they have to have a professional captain. And it totally changes the calculus for them because that's not something they were planning on. They could only find out after acceptance. Michael, what are some of the issues that you've encountered with buyers trying to place insurance as they acquire the boat?
Well, I think Nancy's summary was pretty spot on. The key is that the time between the acceptance of the vessel and the offer should be sufficient to do due diligence. And due diligence, it's not just the obvious sort of finding something that's so out of pattern that what the buyer has not thought of. Maybe the seller's acutely aware of it, but it may not be a yacht broker issue, but it could very well be a marine insurance broker issue. Is some factor that the underwriters have just decided that's not something we can insure. And two recent examples was age of vessel and speed of vessel. Vessels had already been effectively acquired. You always try to figure out a way to maybe back out if you can, legally. But the insurance brokers they go to work and they're not happy about it. I mean, they like to be brought in at the early stages. And that would save everybody a lot of grief. So there's a market out there that's going through a lot of analysis. I'm speaking of the marine insurance market, and they're going through a fairly rigorous data analyst process. Fire suppression systems seems to be something that's coming up where you have old school fire suppression systems, and the underwriters are saying, no, we can't approve that until you have proper fire suppression. It's hard to actually think of things that really don't that are not a limiting factor, and is too little, too late situation. But I would say that starting from the point that the offer is made, the seller at least conditionally says, yes, I'll accept your conditional offer, and you start that due diligence period, everyone thinks of see, trial, and survey. But to me, the big disasters have come out of certificate analysis, something that you're familiar with, David. They don't want to get into that, but those are the bombs. I mean, you have a vessel coming up on the 10-year survey, the second 5-year survey. For whatever reason, the boat has to be in class. Right? That's the model of the owner, the buyer. And yeah, we'll get you in class. It'll cost $2 million to do the work that's necessary. I mean, these are real world examples. And so it sort of relates to insurance because insurance, the two institutions that I think that are overlooked for some reason I think in our world are the flag state situation is completely under thought. It's just not. Everyone just sort of takes it for granted. We'll go into this flag. We're going to that flag, and the insurance piece. So, you know, I'm slow, but I'm dependable. I'll think of other examples, but it is usually a retroactive situation where someone has discovered that a vessel is not insurable. Are certainly not insurable in the way they thought it was, certainly not insurable for the permissible uses that they think the vessel qualifies for. It will not qualify for chartering. It will not qualify for multiple owners, fractional owners. Some underwriters don't like that. What is the record of the operator? What is the history of loss of the vessel itself? These are the things that I think we run into that are, you know, just seem to be problems that are usually discovered very late in the process, unfortunately.
That's something when you talked about certificate analysis, you know, even beyond insurance, just knowing how the buyer wants to use the boat, and how that intended use is going to be affected by how the boat has been built and certificated, how she's been kept up.
Right. Exactly.
And a lot of the problems we see are when those issues don't really become evident until, you know, late in the process or even after acceptance, and that puts the buyer in a very difficult position.
The nature of the boat. Okay, so you have a unique vessel. There seems to be a lot of sort of construction of what I would call sort of unique vessels, unique yards. Okay, I'm not going to be too specific here because it's a small industry, but you know, in a particular case, the client, his business plan was to charter the vessel, and of course he was advised regarding the fact that it was foreign built, the limitations that he would need to consider. He was advised about customs duties and these sort of things, and he was very clear that he had, in this case, he had actually consulted a marine insurance broker. But the vessel was so unique that he could not actually legitimately create a bareboat charter situation, which would be where the boat would be offered to the market with multiple captains being considered. There was precisely one captain who was qualified to operate the boat. Well, the underwriter is not into his business model. They just say, well, this captain's qualified. He says, but I just got a letter from Coast Guard. And they're saying this is not a bareboat charter situation because the captain who was working for you yesterday is always the captain working for the charterer today. So you've got to have multiple captains in your list. You have to have a list of multiple. We'll let you get by if you put 10 names. There was precisely one name that knew how to operate the boat. I mean, I lived through this. I mean, we've been trying to fix it. I think there's a market for this. A training course to teach people how to operate these particular boats. They're kind of unique. They're powered differently. They have different systems. They're wonderful. But they have a limitation in that you have to be specially trained to operate them. So I think in the industry, and I'm sure you've seen it. You know, the form practice. You know, we'll use the form that's available. the contingencies or sea trial and survey. But I think the abbreviation of periods given rise by the quickness of the internet and everything, and we can have rapid communications. I hope this is addressing your question, but it's something that we see is that don't let the seller or the buyer have an abbreviated period before acceptance of vessel, because that's the time when the lawyers, the marine insurance brokers, and the other professionals go to work that really do save your bacon.
And they've probably made a lot of assumptions about what they can do with the vessel that may be proven wrong if you have enough time to look into it.
And I think you were saying, one of you was saying about first-time buyers. That is a phenomenon. It's a time we live in thing where people think, okay, this is my way out. I'll have a yacht, I'll have a boat, I can get out on the water, life is going to be good. But because they're first-time buyers, they are particularly, they're kind of like one step above being a ward of admiralty, like a crew member. They're like, it's like Buffy and Chad. They really have no idea. They have money, but they don't really have much else. They have no real conception of what it means to be a yacht owner.
And not a broker who's not advising them either, because he doesn't know.
Oh, yes. The broker who sold a yacht recently for a wonderful home, and you take a look at the home, and you go, well, how much water is there? And he says, well, that's what I'm here to talk to you about. And I go, oh, you mean it's not enough water for your yacht? Because your yacht's 105 feet. So you got the frontage. What is the depth of water there? It was like 4 feet. And I said, well, you have a situation here. And so who are you mad at? The real estate broker or the yacht broker? Because they both knew of the other. It's a funny thing. The real estate broker knew of the yacht, and the yacht broker knew of the house. And now the boat is useless as far as that house is concerned. So I think that this segment, we're talking about, Mr. The spicy meatball is, wonderful. I'm sure it's a wonderful vessel, but the question is under what permissible uses and circumstances is it a wonderful vessel? That's where the yacht broker comes in. We had a yacht broker recently sold it to a family of 9, a 55-foot boat. Family of 9, well, they barely will fit on that boat. But all of his sea trials were done with him alone. And to him, it looks huge. It's a big boat. It's a yacht. And you're saying, well, actually, it's actually not a terribly big boat. But it is a wonderful asset for sure. But he's now got a boat that's day one too small for his family. Because in his insurance, Nancy, there was this first-time operator. He doesn't really know how to operate a boat. The boat comes with an operator, which is to the credit of the seller, to help him learn. So that got that piece covered. But now you're adding an operator on board with a family of 9. It's not good.
I think part of what a good broker does is they really learn what the client's looking for. Mm-hmm. And if he's alone on the sea trial and he lacks the imagination, what's this going to feel like with 9 family members on board? Exactly. A good broker will remind him, hey, you wanted to use this with your family. Do you think this would be comfortable?
Totally. The odd geographical conditional acceptance conditional acceptance is can the vessel do certain things that the buyer thinks it can perform, certain performance characteristics, and they built this into the purchase price. You need to have the purchase offer, I should say. You need to have a very clear conditional offer with the metrics of speed and distance, and under certain conditions. So you really need, and we've had a yacht here in Fort Lauderdale that's, the weather today is perfect, right? But for the last, if you think back just a few weeks ago, for several weeks, the weather was terrible. And they were canceling sea trial after sea trial after sea trial after sea trial. And that's not just, let's get down to the boat today and have a sea trial. It's like it's crowd control, right? But I think they canceled 5 times. To the captain's credit and to the surveyor's credit and everyone else, because there was going to be a fight. We have to perform. We have to have certain RPMs, and we have to have certain speeds, and we have to have fuel, and we have to have this and that. Anyway, that was all on the conditional acceptance. And it was pretty interesting how that became such a major sticking point when in your practice and in your experience, it may not have come up that much.
No, I mean,
past,
that's more often an issue on new builds where you have liquidated damages for
Exactly.
deficiencies and performance characteristics.
Exactly. But if you're we had this case where it had to do with the so-called Orcas Island off Seattle. You'd kind of start from Seattle and kind of go up and over. I'm not sure but these boats, this particular boat would always run out of fuel. And pretty dangerous situation. You know, you're on the open ocean. Really, it looks close on the chart, but it's far away. And it led to a pretty serious lawsuit, not only on the part of the buyer against the seller, who had written into the acceptance, you know, I'm going, this boat is fit for travel to and from Orcas Island. This was his dream. This was his fantasy, that the boat would go out and come back. It was a beautiful thing. It would go out and come halfway back, and it would putter to a stop. That happened twice. The second time, he was certain that he had filled the tank, and it became a very big problem. And it became a problem for the manufacturer as well, because the manufacturer was actually advertising the range of the boat.
But so this was a warranty in the contract, so he was able to go after the seller for damages?
They go after the seller for damages, and the seller was able to go after the manufacturer. Because the seller said, well, the range is advertised. Here's an ad, by the way. He's like, oh, okay, that's good, because that was going to be our next question. Do you have anything, you have a picture of your ad? I said, sure, it's right here. That's what they say. The most beautiful thing was the call to the engine manufacturer. He said, we've been waiting for this call, and we're not happy about it, because these are our clients, and we're going to have a problem because we have letters, we don't think you should be saying this, we think you're maybe overstating. But all of this is kind of related to, you get the occasional acceptance, a conditional acceptance that says, you know, on condition that, but that's just a part of the contract, as opposed to on condition that you pass sea trial and survey. Okay, everybody knows that one, so they pass sea trial and the conditional acceptance is met. But something you said, and it brings a little chill, you know, because these are all our friends, right? This is a problem with our industry, is we know all these people. So the best surveying company, by some people's opinions, in the world. I mean, I'm just saying, some people would say that. If you said, what do you think is the best marine surveying company in the world? Name the top 5 brokerage houses in the world. So you get another name we all know and love. So the surveyor does their work and says these are all the problems with the issue. Now, meanwhile, the buyer is telling the surveyor, oh, we'll just take the surveys that were done the last time when the deal didn't go through. This guy's buying a $20 million, $30 million boat, and he's going to accept some survey that he had no control over. The surveyor gives him the old survey with the permission of the party that owns it. And then the broker flies to the vessel and surveys and certifies that everything on the survey was done. So conditional acceptance, all factors met, right? The buyer goes forward with the survey. This is where you come in. Then he notices that the second, fifth annual survey is due. And they go to a yard in France, nice yard that's working hard to get big boats in there. And they find amazing things wrong with the boat, millions of dollars. So now we have a very unhappy billionaire, not a good thing. We got a surveyor that's got a pristine reputation in the crosshairs. We have a yacht broker who's certified in writing, happy, 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 everything was perfect. And the deal goes through. So I guess the point I'm trying to make is conditional survey, don't go to sleep on that. I think people have gone to sleep in this industry to some extent. Oh, well, it's C-trial and survey. Are you having a survey? You having a C-trial? Oh, yeah, okay, we're good. Well, better be dig a little deeper. Anyway.
I think especially for boats that are in class, knowing where she's at in the survey cycle, that timing is really important. I mean, I think we recently sold a boat that was actually, I think we closed while she was hauled for a 10-year survey. And so there had to be a holdback to make sure that all the survey items were addressed and that we could get a class certificate without condition. So the buyer would be able to use the boat. Nancy, one thing we've been talking about is first-time buyers. And I was wondering if you had thoughts about sort of what are the challenges that face first-time buyers when they try to place insurance?
So there's, depending on the size of the vessel, it could be a bit different, but there's everything from, as Michael said earlier, somebody buys a boat thinking that they are going to be able to operate it themselves, and there's some manufacturers that sell their boats as being owner-operator capable, but that also assumes that the owner-operator has prior experience. It doesn't mean I can just go buy one and use it, but that's the way it comes across to some buyers. Unless they're told otherwise. So you've got that element of it, buying a boat that's too big, well, that an insurance underwriter would think is too big for you to use without professional help. And then if you're not going to be operating your own boat, so it's a larger yacht, there's, again, the perception that someone who's buying a new boat that's never owned a large yacht before, it really doesn't know what to expect. I mean, they're probably somewhat right about that. So if they look for those people to have professional management, from a recognized, professional manager, not I'm having it managed in-house or by my captain, but a truly professional manager. And so, again, the playing field is smaller than it was 3 years ago today. And when you start to knock some out completely because, well, those underwriters won't underwrite someone for the first year, and then those underwriters won't underwrite someone the first year, even if they are professionally managed. And then you get the folks that are buying a good deal. So they might be buying a bit of an older boat for a lower price. Underwriters see that and say, oh, he doesn't know what he's buying. There's going to be a lot of maintenance required, a lot of upkeep annually for that. And so that knocks out some people. So really, and it doesn't have to be a treacherous experience to get insurance, but it needs to be eyes open, full disclosure, time, and a professional that both, on all sides, the broker professional, disclosing information about expectations and budgets, working early with the other professionals on the team to get it done. So
we actually recently, something you said reminded me, we had a deal recently in our office where it was a seller who was a longtime owner, large yacht, and not professionally managed. It had been done by the captain and the seller CFO, who were very experienced and able to take care of everything. But we were representing the buyer. The buyer was a first-time owner, and I strongly suggested they look at a management company. I wasn't thinking about insurance. I was just thinking about sort of the ownership experience and what they were walking into. And I think that's...
Good advice. Good advice. Use them as long as you easy in, easy out, but until you're completely familiar with this beast that moves around and is fantastic price, and it's got all these different systems. I mean, it's you all these nightmares. And so, what did you do after the second time on the alarm? Well, I disconnected it. Oh, okay. Didn't investigate? No. Oh, well, the good news is insurance covers negligence. What do you mean? I said, well, it's negligent to do what you did. So maybe you got lucky here, but I'm not sure. We have to read the policy really carefully because this is not a good thing. But it's an example of someone just not appreciating that they weren't trained in the management systems and weren't trained to recognize the danger that they should investigate, not eliminate. They eliminate the alarm. You actually go into the bilge, figure out what's going on down there.
Well, and then to your point, in the insurance world, especially someone like me that's been doing it a very, very long time, you tend to start to rely on patterns and habits and what has just happened, and we've had this kind of rolling along of 9/11 produced certain things, and then market went soft, and now here we are in a time of complete uncertainty, and underwriters are making decisions differently today than they were even literally yesterday. And so, we're telling everyone you can't rely on what you knew or you thought you knew even a few months back, because yacht brokers, to their credit, the good ones at least, they are aware of what's going on, and they do keep in touch with the community at large to find out. So they could be giving advice to their new buyer, unfortunately not knowing that advice is now a day old and therefore stale. So that's the new norm, is don't assume anything that you knew. Pick up the phone and call and find out.
So one of the other things I want to talk about that was touched on in this last Act 3 was the conditional acceptance.
Sure.
So in this case, the conditional acceptance was a price reduction and some pre-closing work. What kinds of things do you normally see in conditional acceptances, and are there any that you think sellers are especially wary of?
Well, I think it's the one thing about the beautiful balance of the properly drafted contract is the very things that the sellers are worried about are the things that protect them. And they don't, initially they see that as a problem. Sometimes that's on the buyer's side. So the thing that I think is sellers are, they worry about still owning the boat 30 days down the road. So you have that initial problem of, how do I get out from under this boat that I'm no longer in love with it? I've already bought my second yacht, so now I'm the proud owner of a second yacht. I just want one yacht. And so on the one hand, they kind of want to abbreviate the time periods. But when you do that, you're also creating a situation where the buyer may not be doing everything they should do to make it a happy circumstance going forward. So to me, the whole dynamics of due diligence, as painful as it may seem in the short run, is the very thing that keeps everybody, out of trouble. And I think you touched on it earlier, David, on the new build situations. It's often the case that the yards and the buyers are fighting, and what is the acceptance going to look like, and this will never work. But the reality is, the very thing that would protect you is the one that will cost you the multiple buyer that will fall in love with your brand and buy 5 yachts from you. The broker makes 5 commissions and everybody wins. And an example of that would be the yacht owner. And I'll get back to your specific question. I have a specific example of what I think is the most commonly seen problem with conditional acceptances, and that is, but in this particular case, the owner wanted his yacht in the Med, and he wanted it there on his wife's birthday. There was some delays. The boat was in pretty good condition, but not yet finished, not the way it should have been. But he was already kind of in the Med, since it was an Italian yard, but he wanted it in Monaco, and he wanted to do what people do. They wanted to enjoy their life and celebrate their love of their life's birthday and the beautiful new yacht. But the marine surveyor said that the cost of finishing the boat would be a mere $1.6 million. And the yard wanted to set aside $160,000. That was their number, was $160,000, and now we're talking to a guy that's done 4,000 surveys, and so he says it's going to take $1.6 million to bring it to finish the handover on the acceptance, and it turned out that the number was much closer to $1.6 million. But the way that interplay, a fraction of the cost of the boat, we can all agree on that. But the disharmony and the anger and the irritation that this yacht owner felt in that little problem, $1.6 million was not a problem for him, and he readily agreed, that we should try to work this out. But the way the yard handled his advance payment of the $1.6 million and the way they were so horrible in terms of accounting for it when he went back to the yard for the finishing work. Let's just suffice it to say he's now like his third major yacht, none of which was bought from that yard. So here's the point, though, expressly, and we talked about this a little bit just among ourselves, sharing notes a moment ago, I think before the cameras got turned on. So you have an acceptance of vessel date. So the buyer needs to understand that this is a conditional contract, and that cuts both ways. It is an illusory contract. It is conditional. It's not enforceable. If the conditions are not met, usually in the sole subjective opinion of the buyer, the boat comes off the market. So now the buyer has received a survey, and he wants a price reduction, or he wants things fixed prior to an agreement to have things fixed. And what he doesn't know, though, is that the seller has received a much better offer of a very motivated buyer who's now putting cash down and putting it in a trust account and making sure that he sees it's there. I'm serious. He's basically incentivizing the seller to say, the moment that last day comes, boat's back on the market and I'm selling it to this other guy. And of course, the buyers get confused, thinking that by counter-offering, they've extended the acceptance of vessel date. And that's probably the single most frequently seen mistake that the buyers and sellers, and particularly the buyers who are not well represented, they're late. We get these. I'm sure you get these all the time. We'd like to close next Friday.
If you have a boat with a survey contingency and you accept for the acceptance date without condition, you can keep the seller in the deal.
You locked them in. But
if you do anything else, you're giving the seller a way out.
Boom. That's it. And that is as clear a statement. You should record that. And no, seriously, just record it, just like you just said it. And to say, okay, hang on a second, let me just play something for you here. Did you get that? No, let me run it back. Because I think it is a tragically, the buyer wants the boat and he's just a business person. He likes to negotiate. He likes a deal. He likes to, he likes to feel like he got a break. And so he'd like to charge a few bucks.
It's just like the scenario. Chad saying, just offer him this, and Bubba saying, why do we need a lawyer? I mean, it's ripe for this exact problem.
And the guys, they don't know Mr. Figurino's attitude. They see the boat, but there's two brokers in the middle, both trying to create this linear communication change, but keeping certain things. They don't really know the true attitude of the seller. They don't know that, and the brokers in the middle prevent the listing broker from really knowing the true relationship of the buyer to how motivated are they, and does Buffy have to have it? Which I always love that, because I've heard that a few times. Don't fall in love with the boat. There's another one right behind it. Get the one that's right for you. That's the important thing. But yeah, it's a conditional acceptance, and that does mean. But I think more deals go forward on that premise than when you try to lock them in on some of these contracts you see from time to time. I think you see a lot of people that would have closed and would have gone to closing that walk away because they just don't like being locked in. They feel like they're being pressured. Whereas if they go through that process, particularly if they spend that money for the survey and the sea trial, chances are they're going to go forward. So we have a deal that's coming in this weekend, and it's another one of these deals, conditional on a cash and a trade-in. And I went, yes, the old trade-in. So the old boat is not sold. So the buyer wants a new boat, and it's just got little red flags kind of popping up, and you go, no, look, I want the deal to go forward. It doesn't matter to us. We're lawyers, and that's a different personality, a different situation. But that boat down in that trade-in boat, there's a reason that boat's still on the market. There's a reason that the buyer has gotten ahead of the curve, and he's not even doing the traditional use the old boat till the new boat is available. So you're saying to, in this case, your client, well, you better make it very clear that you're basically, it's a whole nother deal. You have to go down to, well, not to say the countries, but you have to go to where the boat is and really do a proper survey. And you're going to have to fly in someone that knows what they're doing. You don't get a local yokel, get a yacht surveyor. So it's conditional. Everybody loves that word, conditional acceptance. But I said you're going to have a problem if you don't have we don't write it so it's a clear justification that you're in your sole discretion, and it doesn't matter if he's a SAMS member or some other accredited surveyor, but they might want it to be. But that's a problem.
And this is something actually the MEBA contract does a little differently.
Exactly.
Because they don't have a sole discretion standard. They have this sort of more elaborate regime where you have a survey and you have defects as defined in the contract, and then there's a period to negotiate.
Yeah.
And I guess I see the logic of that, but from my point of view, particularly from the buyer's perspective, there's so many sort of deadlines and sub-deadlines and traps that unless you're really on top of
I totally agree.
where the contract is. I think the good thing about the EBA contract is that, there's a single date for acceptance. Everyone knows when it is. The buyer can walk away for any reason. It's just very clear expectations for everybody.
I think Mr. Boatwise said something that was correct, and he talked about lawyers helping draft that contract, and he's right about that. Every time a deal goes south, some lawyer knows about it and knows why it went south and sees the word that is, created the ambiguity. Everyone reads their contracts after something's happened, but the EBA contract is a beautiful form. It does protect the brokers. I mean, I think that's true. That's a criticism of it, but it is a form, and it's full disclosure. It's the International Yacht Brokers Association form. But in terms of litigation or just unhappiness, the MEBA form has generated a lot more unhappiness and more litigation.
That's something I've never understood when people say that you should use a form because it's litigation tested. Mm-hmm. Why would I want to use a form that's given rise to so much litigation?
Oh yeah, it's completely done that. The conditional acceptance sort of issue, but it came exactly as you said. The buyer and seller, shall we say, disagreed on whether the contingencies had been met for their respective positions, and so lawyers do have their honest views. They have their views, their public views, they have their private views, and they say to their clients sometimes things they don't say to the other side. But in this particular case, of course, you have English arbitration. And so they appointed these 3 arbitrators. Oh yeah, all members of the London Arbitration Association. And they all sat and they all submitted their initial fee statement. So I took that fee statement, I sent it to the clients in California. I said, well, now this is the initial fee statement. And I like to repeat my recommendation. You two guys are literally big boys in the financial world. I highly recommend that you get on a plane and go sit down with a guy and work it out. And he says, I'm on the plane. He says, I'm not going to pay these guys this kind of money. It was $1 million was the first fee note.
That's something that I think is really important when you're drafting a conditional acceptance. It's easy to say, this is the contingency, but it's important to say who decides that it's been met. If there aren't objective criteria, mm-hmm. Is it the buyer surveyor? Is it a surveyor chosen jointly? I mean, whose decision? Because if you end up in a dispute about factually whether a repair has or has not been made, you don't want to have to go to LMAA arbitration to have that resolved.
It's a very painful experience.
One thing that has come up at a couple of different points, we've talked about timing and sort of how deals unfold. And I wanted to ask you sort of, what sort of lead time do you think is minimum or is best on a deal? And I understand it depends on the size of the boat and a lot of other factors, but at what point do you want to get involved in the process?
Well, the answer to what point is as early as possible. As I mentioned, even if, in fact, we had one recently, which I thought was a fantastic approach. The prospective buyer was not even sure. He had narrowed his window into year couple years here and feet here, but he wanted to then understand the process from there. So it was like an interview of what next, and I thought that was fabulous. 60 days later, he called and said, "Okay, now I've got my boat." But he was fully prepared for what next. But even when people don't do that, ideally several weeks at least for a clean survey, a good plan, and several weeks. And at worst, I mean, people will call, we're closing tomorrow or the next day, and it can be done. But it's I always tell these people, kind of, it's the same as when you went to find the boat that you wanted to buy. If you went into the seller and said, I have to have that boat and I'm closing tomorrow, you might not get as good of an outcome as if you'd said, I want to buy that boat, but let's go through the process and give it some time. So it's really the same. Insurance is a negotiation, just like buying a boat.
I can't remember who said it, but I remember hearing once, there are three things you want out of a deal or out of something you're buying. You want it good, fast, and cheap. And generally, you can only pick two of those.
It's such a wonderful saying. If I may say, just in the marine insurance field, it was sitting across from Nancy Poppy, David. It's all these wonderful memories, and then all these other memories that are associated with marine insurance, none of which involve you in a negative way, Nancy. I want to be clear on that. But in terms of acceptance of vessel leading to insurance and everything we've been talking about, we have this yacht owner buying a nice yacht, kind of in the $8 million range, and he gets the survey, and he reads the survey very carefully, and he says, I accept the vessel. Very, very nice. I mean, I thought he was for sure going to take this other boat that he had his eye on, but he took that boat and accepted it with its faults because he liked the price and it was big. Okay, so $8 million, he got a lot of boat. Horrible survey. And so I said, well, we should try to delay this. Actually, it wasn't me. I'm sort of merging the story. The truth is, it's one of my colleagues comes in and she's kind of really upset and crying, basically. And why? Because the principal won't let me send the surveys to the marine insurance broker. It's like, wait a second, what do you mean? He says that they'll never insure it if they see the survey. And I said, listen, just act like you don't remember that. Just put it in, send it immediately to the insurance broker. You just have to do it, because if somehow we got to get this done, and he's already down the road. He's accepted the vessel, and now we've got to get this guy insurance. And by the way, who is his insurance broker? Oh, it's the family business in Chicago. Okay. So who is the broker for the family business in Chicago? Well, it's a certain broker. Okay. So she sends the reports of survey to this broker in Chicago, who doesn't send it along to the underwriter, just simply deep sixes it, apparently reads them and concludes the same thing. Somehow thinks he kind of fiddle-faddles and manages to book some insurance, okay? Except that, of course, when the boat sinks, I never will forget it, Super Bowl Sunday, the entire crew was in the crew mess watching Super Bowl. The game was turned up loud, people are cheering, and they don't hear the cascading water and the bilge alarms because they're so excited about the Super Bowl. It's the final, Tom Brady on the 4th and 20, and it's like 3 minutes to go, kind of thing. And meanwhile, the boat is filling up with water and it sinks. Everybody gets off safe, thank God. Except now we turn to the insurance piece. And the problem for the underwriter is that they had allowed, you know where I'm going with this?
Well, I can see where it's unfolding, because if they bound the coverage without it.
And they had allowed this broker to put their name on his website, and that's something that the federal judge went off on. He says, well, I mean, people reading your website, now I'm just saying this because I had never heard this argument before, and I wasn't involved, by the way, I want to be clear on that. I'd like to claim credit, but I'm not in Chicago, I'm in Miami, so very fine lawyers were appointed, and they're arguing this case, and the judge said, look, you got the name of the underwriter on your website. any citizen, any consumer seeing the website would assume that you represent those people. Well, in a sense, I do. I mean, he says, because now remember, the broker he represents the yacht owner. He's kind of in a bit of a conflict situation, but the underwriter is like, come on, you can't be serious. But the judge says, no, I'm totally serious. You're liable. And I'm sorry, the guy, Deep Six, the survey reports that came out. But a broker, the consuming public, and of course the yacht owner swears, that the fact that the underwriter's name was on the website was, that's who I thought I was getting. I didn't really understand that he was my agent. I thought he was their agent. But I mean, the point is I guess the theme of this is conditional acceptance is a lovely, and it's what we're talking about, but don't just accept it on faith. Just kind of just get a little more molecular as to what this means. And that's the thing I think we have in our industry that's a little bit of a concern, because we get so used to deals. We get so used to boat deals, yacht owners, listing agents, selling agents, buyers. And your people that work in your shop, they get a little used to it. And it gets to become, maybe they don't quite stay on the ready alert the way they should be. And I think it's a constant to say, you got to be vigilant. You really got to be. Don't let these high-powered people talk you into things. To be very careful. Make sure that everything that's in that contract, that they're telling you on record that that's what they wanted. They sign off. That all these contingencies have been met. The insurance broker's fully aware. Bound coverage under proper terms. We had one with a navigational warranty. But it was again a little glitch, came up not in the closing per se, but very soon after the closing. No one had really paid attention to the navigational warranty, because they didn't pay attention to where here's the band, and the boat was down here, and the navigational warranty said never south of this latitude. It's very clear the underwriter's in a very strong position to say, the reason we put that in there is because of the weather systems in that latitude. And it's a tough thing. So I just say, you have to get up every day and realize it's a serious business. It's a fun business. It's kind of interesting, but the closing is such a dynamic moment. It's so fraught with exposure and peril and worry, So anyway.
I was thinking, I know we keep analogizing to new builds, but in a new build, you get close to the protocol delivery and acceptance, and you have this definition of minor nonconformities, things that can be fixed after closing as warranty issues. But on a secondhand deal, after closing, you're hoping that relationship is over. You're not going to have to go back to the seller for anything. So you really have to satisfy yourself that the boat is in the condition you want it to be in.
Oh, totally. The strangest things that are ancillary to exactly that. I mean, talking about the new build situation, and it's how you're creating the relationships. You have a crew that's under contract with one yacht. They now are seconded, or not seconded, but hired by the other yacht, both owned by the same beneficial owner. And so the crew is now in Livorno. You can probably guess the manufacturer. I shouldn't have said that. But they're not allowed on board. This all becomes relevant later. And at the time it's unfolding, you may not fully appreciate the nuances of the turnover procedure. And so they're not allowed on board. They're in a crew house or something. They're just kind of stuck in there. They're not allowed to physically get on now, that doesn't matter if this guy's already paid millions and millions and millions of dollars to this yard. They're being kept away from the boat. But it all becomes relevant later when the litigation ensues. But it all becomes like this was a calculated move on the part of the selling entity to basically hide things that were on the vessel. And of course you get into, who were the professionals that did the survey, the sea trial, the survey. I had this guy, a boat passes everything except what I call the old man test. And this is a guy that basically said, I wouldn't want to be on that boat in a following sea. This is something that the underwriters would have loved to have heard, okay? But it was a little bit late in the day, and I said, well, I said, why? And he says, well, how do you know? And he says, Michael, I've done 4,000 surveys. I know. Well, I'm just saying, if I had had the option, I would have immediately called a halt to the whole deal. I would have called you, the insurance broker. I would have called the lawyer on the other side, you, David. I would have. That's the way I'd do it. I mean, that's exactly the way I'd do it. I said, look, we have an issue here. We should look into it. Well, the manufacturer didn't want to hear it. They wanted to push through to closing. And the buyer said, well, so I've got all these smart people advising me. I'm paying all this money. The insurance company's already bound coverage and all these things, and you're telling me that I'm supposed to take the word of that guy over there who's 80 years old, 79 years old. That narrows it down, doesn't it? I said, that's exactly what I'm telling you, and I'm going to tell you why. And he said, why? And I said, the safety of your family. He goes, that's it, we're not closing. So he walks out, and 3 years later, he's proven right. I mean, 3 years of litigation, lots and lots of money spent, fancy naval architecture, model testing, place in the Netherlands, the state of the art. They run it through, and they say, well, here's your trouble. And so you see this? That's your trouble. And it's like you're looking at graphs and things going up and down, and instead of not going up and down.
But it's something he could just sense.
He could
on the
feel
boat.
it. That's the point I was saying. So my takeaway from that is, we're here kind of talking about conditional acceptance and what's on the piece of paper, and you have to be, to understand sometimes it's what's not on the paper. And in this particular case, by the way, a captain on a sister ship, there were 3 made in the series. One of the captains walked off the boat, called me. And I said, who are you? And he said, I'm so-and-so, and I'm the captain on board. I said, wow, that's fascinating. He said, I just want you to know I walked off this boat today. He says, it's not a good situation. He says, I'm not trying to cause trouble, but I got a new job, and I just wanted to make that one phone call to you. You're onto something. And, all I'm saying is if you're kind of like attending a seminar and the lawyers say, it's see trial and survey, be a little bit more aware. I mean, the underwriters in that case were phenomenal in terms of stepping up and going to bat and saying, we can help. We think there's a place up in the Netherlands. They were the ones that kind of identified this group. I didn't know who they were. But they're big testing company. You probably know the name of them, but they were the ones that really decided the deal. That they identified the problem. They said, well, we're going to fix it, and here's what you got to do to fix it. You got to take the transom off. You got to reconfigure this, and then put the transom back on, and then you're going to be good to go. But the problem is right there, and we know this because we can measure it as it goes through the water. But the team you put together, a proper team. One of my things, this is not a shameless ad for Allie Moss, but my standard reaction is, oh, that's great. What do you mean? I said, well, because they know what they're doing. My nightmare is the really, really smart person who is often wrong but never in doubt. They're brilliant lawyers. They've never done a boat deal before. And they run the guy, they're representing some huge guy that they love, and that's their baby. They're practically bonded and married to this person. But they're completely out of their depth. And that's the one that's going to bite you as they start demanding things and wanting things, and we should do it this way, and if you can't get it done, maybe they should find somebody that can. You go, okay.
I've dealt with a few of those.
Yeah, I'm sure.
Well, I think that's going to do it. I want to thank both of you for coming and for your time. Thank you, Michael. Thank you, Nancy. Now we are going to go see the 4th act of As the Prop Turns, and I will be back tomorrow with more panels to talk about the issues raised in the story. So thank you for watching.
Thank you. Thank you, David.
IYBA would like to thank Howard S. Reader, Inc. for their support of this year's 25th Annual Yacht Sales and the Law.
Do you want to generate leads? Is free your favorite price? Then you need to check out IYBA.pro. IYBA.pro is your industry-owned platform for all listings and marketing. Create robust yacht sales and charter profiles, elegant marketing material, have access to all your exclusive data, and enjoy premium search engine optimization by signing up with us. For more information on how to join IYBA.pro, call the IYBA headquarters or email me at casey@iyba.org.
Yes, Mr. Ficarino. I'm aware that you're not happy with the conditional acceptance. However, I'm on it. I've already made a handful of phone calls. I can get some people on to fix the items quickly and cheaply. And as soon as the items are completed, we'll get the surveyors back on board to take a look at them and sign off on them. Don't worry, I'm on it. I've taken care of it. Okay, sir. Thank you. Bye-bye.
Idiot drivers, what the hell, man? Just pull right out in front of me. God, dog.
Hey, Bubba.
Hi, Bill. I sound all right. I'm on the new car phone. Can you hear me?
Yeah, okay.
What's up? What do you got?
Mr. Ficarino is not happy with the conditional acceptance. That's not going to work.
Yeah, and?
So we are going to have to get these items addressed and fixed. Can you get somebody on board to address these items so we can send the surveyors back out to the boat so they can approve all the items?
All right, look. I'll handle this. I got a guy right here who can handle it. I know a captain can take care of all this stuff.
Okay, that's what we're going to have to do to get this done. Bubba, I'm getting on an airplane. I'm leaving. Can you figure this out for me?
Just go make your trip. I got this covered. No problem. All right.
Okay, Bubba, let's get it done. Thanks.
She can even be ugly. I'm married for money. Put your walker over here. Well, that's interesting. Seems like Bubba's a pretty good guy, and he's learning a little bit. But I think we've come to a point where Bubba's out of his depth. Thanks for joining us today for day one of Yacht Sales and the Law. Stay tuned. Tomorrow, we'll see how this all ends.
This 25th Annual Yacht Sales and the Law has been brought to you by Allie Moss, Rogers and Lindsay, PA, Yacht World, Lauderdale Marine Center, Howard S. Reader, Incorporated. Our internet connection has been provided by JV Connectivity. And our generous hosts for panelists and production team were Pier 66 Marina. See you tomorrow.